Welcome to Case by Case. This is a podcast series brought to you by Xylophone Zatkovich, hosted by Luke Zatkovich and Calum Chain. We're excited to get underway today because this is the first of our second series. We're just coming back from a break. How are you, Calum?
I'm good. I'm refreshed, and I'm looking forward to another series of Case by Case.
And this is a exciting one because we're doing this with a special guest today, Philip Vagin. How are you, Philip?
Great. Thank you so much for inviting me here.
You're welcome. It's a pleasure to have you on board. This is the first time, actually, Calum, that we've had a guest.
First time with special guests. First of many, we hope.
Yeah, exactly. And we're coming to you from sunny Norfolk in England from our global retreat. So we stepped away to punch out one of these podcasts, and we've got an interesting case today to talk about. This is a case, it's a London Arbitration case, maritime case, 9/21, and it's all about maritime liens over vessels for bunker supplies.
Exactly. And so it's a situation that we see relatively frequently, and I will preface what we say in this case with the normal health warning when we are looking at an arbitration award, which is that we don't have, arbitration awards run to 1 page, 2 pages. The English court judgments will run to between 20 to 50 or more pages. So there's much richer information in the court judgments than what we see in the arbitration awards. But this is a very interesting one, particularly to look at the English law against the US law position, which we're delighted to have Philip talking about some of those points as well. Perhaps before we do, we'll just go through the background, which is reduced to about 2 paragraphs in the page. So
this is a short one. We've got a page and a half of summary here to work with, and it does get into some detail which we'll touch on. But it's not the first time we've had a case where the quantum involved is actually not that great. It's a $30,000 case.
You'd be surprised if that quantum was not overtaken by the legal fees arguing this point. Either that, or it would have been on the small claims track.
Quite, but this is also a case where the respondents didn't turn up.
That's true.
So it was uncontested. So costs, maybe weren't as high as they would have been had it been contested. So out of the two of you, who would like to give us a summary of the facts?
Phil, why don't you? It's you.
All right. So it's a scenario which we see relatively frequently in the shipping industry of a physical supplier of bunkers. That is the company that actually produces the fuel. It gets unpaid, and it then seeks security in the form of a ship arrest. It tries to detain the vessel to which the bunkers were actually supplied and get a money judgment out of it. So this is what happened in this arbitration award. The interesting feature, I guess, about this case is that the arrest appears to have taken place in England, and the arbitral tribunal sided with the claimant here in recognizing that under English law, actually, claims by physical bunker suppliers gave the claimant a maritime lien against the vessel. We'll talk about, I understand later, about the nature of maritime liens, what those are, and how they come about to play in the bunker supply context. But surprisingly enough, I guess that's the background to that case.
Well, exactly. And it is not totally clear on the face of the award, correct me if I'm wrong, that this arrest did take place in the English jurisdiction. But that will certainly provide the most fertile ground for discussion amongst English and US lawyers. So I think we'll assume that it did. There are a number of questions that come out of this judgment, not least jurisdiction, but I think most interestingly, to start off with, the nature of a English law maritime lien and the creation of an English law maritime lien by contract, which appears to be what the award has said has happened. So I think probably what we have to do to explain this well is to step right back to the start and to say, what is a lien and then what is a maritime lien? And I think, well, we see liens a lot. We see liens in charge party disputes. We see lien clauses in voyage charge parties, rising of freight and demurrage. We see liens in time charge parties. arising over any amounts owed to owners under the draft party, and those are contractual liens, and those allow the party with the benefits of the lien enforce their lien, to assert their lien against the other side's property, against the cargo, is in the voyage draft party context, for example, until they've been paid the thing over which the thing in respect of which they're asserting the lien. So, for example, if freight's not paid, then typically a voyage charter owner can assert a lien over the cargo until payment is made in terms of freight, and that's a contractual lien. What we're talking about here is a lien that typically arises by operation of law, and US law position on liens for a bunker supply is different, I believe, correct me if I'm wrong, Philip, to the position under English law.
Yeah, I would say it's quite the opposite. So it's entirely different, and we'll discuss later about how that difference plays out in very similar factual scenarios. But I just wanted to perhaps give a quick rundown of why maritime liens, as opposed to other liens, are so special. To me, there are at least 3 characteristics of maritime lien that distinguish them from the rest of other security devices that are available to maritime claimants. The first one, and the one which makes it so strong as a security device, is that a maritime lien follows the vessel itself. It follows the thing into the hands of even a good faith subsequent purchaser for value. So it doesn't matter to whom the vessel is sold subsequently. It still continues to attach to the vessel until it is either waived or until the vessel is sold pursuant to a court order. It is usually an order of a court of maritime jurisdiction, not a private sale. So that's the first feature which makes a maritime lien such a favorable device to claimants. The second is that it usually gives the claimant a so-called super priority. So in bankruptcy proceedings, the claimant holding the maritime lien enjoys priority even over other claimants who have their claims secured, say, by a mortgage or by a regular lien or by some other type of charge recognized by a particular national law. And perhaps surprisingly, courts in many jurisdictions are rather consistent about recognizing that priority of maritime liens over other security devices. So that's the second feature. And the third one, the last one, is that most jurisdictions allow claimants with maritime liens to arrest the vessel. So it's not only a thing that gives you priority over other competing claimants, it's also a procedural device to some extent, which allows you the opportunity to arrest the vessel, not just the vessel. Some jurisdictions recognize that maritime liens may arise against cargo, against freights or sub-freights, but usually and most often a maritime lien gets exercised against a vessel.
And when you're talking about a maritime lien in this context, Philip, are you talking about the type of lien that arises by operation of law, or are you talking about a contractual lien?
So the classic maritime lien, as they arose in ancient history back in the Rhodian laws, I suppose, was that lien arose by operation of the law to secure claims by relatively unprotected creditors, such as seamen, for example, who did not get their wages paid, or by victims of collisions, for example. If the two vessels collided, there's obviously no way there's a contract between them, although such situations may also arise as well, for example, in the towage context. So usually a maritime lien would arise by operation of the law only. And it was thought until a certain point in the early 2000s, I guess, in the United States, that maritime liens could not be extended by contract. That because they were such powerful security devices that give so much protection to creditors, even against subsequent good faith purchasers for value and other third parties, that they should not be extended by contract, that the parties should not be allowed just to create a maritime lien, a very strong security device, by virtue of their private agreement, seeing that it might affect the interests of third parties.
So the idea is that these liens could be well, they could be and they would be created outside of contract, because a contract was not necessarily in the contemplation of the party that later benefits from the maritime lien. So, for example, in the collision context, you don't make a contract with any party with who you may collide during your voyage. Be reasonable. And then there's a different take on the law in respect to the way that these operate under contract, which is almost to say they're so powerful and they're such a good tool against other third-party creditors who perhaps have contracted for a mortgage, and therefore the law shouldn't recognize the operation of those liens by contract alone, because to do so would be to, in a contract between two parties, you could overtake a mortgage interest in the vessel.
Yeah, and I think it's worth unpacking this a little bit, I think, Calum, because if we look at this particular contract here, as I read, there's almost two bases upon which a lien has been created. We've got an express clause 3.2, which reads in, is it 3.2?
I think 3.2, yeah.
Yeah, 3.2, which reads in that bunkers will be delivered to the account of the buyer, and that will always include the vessel and her registered owners. And this claim was brought against the registered owners, the managers, and I think another party who ordered the bunkers. And as you read on in that clause, there's an express warranty that the claimant has maritime lien on the vessel for any bunker supplied under this contract. Then it refers you to the applicable law clause. So that is a contractual lien. That is a lien that is arising by operation of the contract, more so than operation of law. But then the contract goes on under the clause 17 and incorporates in its governing law clause the general maritime law of the United States, and expressly then says, with respect to the existence of the claimant's maritime lien, claimant shall have a maritime lien on the vessel until payment and interest lien costs are being received by the claimant. So it's almost like it's another route in this instance by which a lien is arising, and that is by operation of law.
Yeah.
And so that's where you get the US lien right over necessaries, which bunkers are. It's a statutory lien that arises. And you have both of them operating here. And I suppose the question that I'm posing, Philip, and Calum, is when you talk about those three features of a maritime lien, particularly one that survives a change in ownership, you're talking, as I understand, about the lien that's arising by operation of law, the statutory lien. If there was, for example, only the contractual lien, would that have survived ownership?
It wouldn't have. So usually it's only the maritime liens, strictly speaking, that give rise to a right that follows the vessel, that follows the thing into the hands even of a good faith purchaser. So we need to be quite careful about distinguishing, I guess, between contractual liens, which, for example, arise under the New York Produce Exchange Shelter Party, which are created expressly by words of the contract. They say that the charterer shall enjoy the lien over the vessel, and this type of lien, it will not follow the vessel into the hands of a subsequent purchaser. By contrast, the liens that have been traditionally recognized as maritime, for example, for seamen's wages or collisions or salvage, or for port or canal dues, these will follow the vessel into the hands of subsequent purchasers, and they will usually have super priority. So even if there's a bank which has a ship mortgage on that vessel, it will have to yield to the claims of true maritime liens creditors, like seamen, for example, or the innocent ship in a collision.
And the normal position, as I understand it under English law, is that if you were to have an attempt contractually to include a maritime lien, then English courts will only recognize that as a maritime lien if truly the same event would have given rise to a maritime lien had the event occurred within the English jurisdiction.
So the position as a result of the judgment of the House of Lords, or rather Privy Council, not the House of Lords, in Halsey and Isle case, is that under English law, and this point requires a bit of unpacking. Question of creation and existence of maritime liens is a procedural one, because English courts underline the procedural function of maritime liens as giving rise to arrest. So in the Halcyon Isle case, the Privy Council, as a matter of, well, Singaporean and by extension English law, only those liens already recognized by the law of the forum, in that case Singapore, but also by extension England, could exist and could give super priority, could give the right to follow the vessel and the right to arrest. So that's the position actually espoused by most maritime countries in the world, because English law has been so influential in this respect. Even civil law jurisdictions follow that approach. For example, in Russia, which has recently codified its maritime law in 1999, you've got the Merchant Shipping Code in Article 424, which says exactly the same thing, that Russian courts will only recognize the liens already recognized by Russian law, because this is a matter of procedure, and the parties cannot, by their agreement, change the procedural rules which the court of a given jurisdiction will apply. For example, well, you cannot tell the court how to, render a judgment, or what the proper time for, say, hearing an appeal is. And the logic behind is that there are procedural matters which the parties cannot agree on, and there are substantive matters which are amenable to parties' agreement, and in most countries, maritime liens are considered procedural in nature rather than substantive. Well, that is a bit of a debatable point, actually, because it is considered that in the Halcyon Isle, the Privy Council was quite mistaken about the procedural substantive distinction, and that the cases that the Privy Council referred to actually say it's more substantive. But that is, with all due respect, quite ancient history, 19th and 18th century decisions, which hardly have any assistance now. So it has been settled in most countries by far that maritime liens are procedural, and it means that the parties cannot change them by agreement. And until that London Arbitration Award in case 9/21, it was thought that position under English law was just that. You cannot, by contract, expand the list of maritime liens.
And although as you say, this is settled, it is maybe worth reflecting on that Privy Council case, because it was a narrow majority. It was 3-2, and yeah, as you also say, there's more modern commentary suggesting that position actually is mistaken.
Yeah, so the Halcyon Isle is a fascinating case in that the 3 judges that decided that maritime liens were procedural in nature rather than substantive had very little experience in shipping law and maritime disputes, as I understand. And the 2 judges that voted in favour of keeping maritime liens substantive had the most experience out of the entire bench in handling shipping disputes. So it may be quite debatable still whether the majority in the Halcyon Isle was right. But that decision has stood for quite a while, and it has been reconfirmed, as I understand, in 2010 by the Court of Appeal in England. And it has definitely been recognised in other jurisdictions as very influential, since even countries adopting new maritime codes and implementing their own maritime legislation have followed that approach.
And is that the same approach in the United States?
No. As in several areas of maritime law, the US courts and English courts take a rather different approach to how things should be decided.
And this is, just jumping in, I think this is one of the reasons why we see US law in bunk supply agreements.
Yeah, and that's exactly how US law plays in here. So what usually happens in a typical bunker supply transaction is that bunkers are not sold directly to the registered owner of the vessel. Or what typically happens on the side of the ship, on the side of the buyer, is that there's a registered owner which holds title to the vessel. There's usually the ship operator, the company which takes the majority of operational and technical decisions about the vessel. It may very often be a ship management company which, for example, hires crew and does so under a services contract, which is made on a ship management contract form. And usually ship managers don't hold any legal or beneficial interest in the vessel, so they just serve it, because it usually, under all time charters, it's the responsibility of the charterer to supply the ship with fuel. So it would typically be the time charterer who would be the buyer of the fuel. And you would appreciate that for the seller of the fuel, that would be a bit of an issue, because the time charterer does not own the ship to which the fuel is being supplied. So what many bunker suppliers have come up with is this idea of inserting either a US choice of law clause into the contract of supply, or stating expressly, as is the case here, that a maritime lien arises, the contract is governed by US maritime law, and that the buyer, whoever he is, be it a time charterer, a bareboat charterer, a manager, or an operator, warrants that a maritime lien will be created. And then if the bunker supplier gets unpaid, they go to the relevant court, for example, in the United States, and try to arrest the vessel and have it sold or threaten to be sold to get some sort of security.
Well, that's interesting, isn't it? We've got the difference between English and US law on maritime liens. We've got the creation of contractual liens versus the incorporation of a law, so US law in this instance, which then brings in a statutory lien giving the seller, bunker sellers, some more priority in a security battle with others, and also the ability to survive changes in ownership. And yeah, we saw this play out, didn't we, in the OWB side with the res cogitans as well, that traversed all these sorts of issues. And there's been a number of recent cases in the bunker industry and bunker context dealing with liens and how to enforce them. So it's an area of law that has had a lot of interest in it, over the last, 5-7 years. Sometimes passing's probably longer than that. So I highly recommend it. Look, if you're in this area and want to know more, then any of the guys here would be happy to answer any specific questions you've got. Have you, Calum, got any kind of passing words on this, or Philip?
Yeah, I was actually hoping to discuss a bit more maybe why the US position is so drastically different from the English one.
You can't stop Philip. We're getting talking about liens. All right, get in short form, Philip.
Yeah, in short form. So it all boils down to how the US courts interpreted a very old English decision called the Bald-Buckley in 1842, which states exactly that maritime liens are substantive. This is a right in the thing itself, which moves with the thing. And if you're limited to a particular jurisdiction, then it loses its effectiveness. Now, for example, say the law of the United States recognizes a lien for necessaries. But what if a necessary supplier goes to Singapore and tries to enforce its right there? Well, it loses its effectiveness, and the supplier has way less protection if the lien is procedural and not substantive. And the US courts have stood firmly in favor of that substantive view, and they even expanded it after several decisions in 2008, 2009, where they went so far as to say that the parties can actually contract to apply United States law to a transaction, even if it has no connection whatsoever to the United States. And I think this may be the context in this arbitration.
That's what we have here.
Yeah. So we don't have any indications that any of the parties is a company registered in the United States.
Yeah.
We don't have any indication that the fuel itself has been supplied to a ship which, for example, would fly the flag of the United States. So virtually none of the connecting factors here point to the United States law. Yet the contract provides for the US general maritime law to apply and for the lien to be created. And I guess my main concern with this decision is that, first of all, it doesn't necessarily reflect how the law has been applied previously. None of the US cases up to 2008, 2009 has held that the parties can choose, say, US law to apply to a transaction and create a maritime lien like that. So
Because it's done commonly. This is not an irregular thing.
yeah, this is not an irregular thing, but I guess it's the distinction between what is being done in practice and whether this is correct.
But I think the point also is critical, and this wasn't the case here, but it's critical against the innocent third party purchaser.
Yeah.
But you would typically then have a claim against the owner, because you would almost always sell the vessel. The original owner would sell the vessel with a warranty that it's free of encumbrance and free of maritime liens. So the route that you would normally see is that the new owner has to face the music against the bunker supplier, but the original owner is then liable to the new owner under that sale agreement. And what it strikes me is this whole question of the incorporation of a maritime lien by contract is a question of competing interests. If you don't allow parties to create that lien, then bargain that those parties have sought to create is not given effect to. However, if you do allow the parties to create that maritime lien, then the bargain that those parties may have created with other third parties is you just ride roughshod over it. And you say, it doesn't matter that you've got this mortgage, doesn't matter that someone else has these charges against you or against the vessel. We get our money first because we have this agreed maritime lien. And I suppose also, if you're looking at finance, say, if you're looking at the kind of, the answers to the interrogatories the banks might send you but before, or the warranties you'd sign up to in any financing arrangement, you may be in breach of those by the existence of contractual maritime liens.
Yeah, because there's often provisions against creating liens that might prejudice the security that the bank has.
Yeah. So, and at the current stage of the development in the United States, US courts lean heavily, way heavier than in other countries, in favor of freedom of contract. And they say that whatever the parties have agreed in this particular supply transaction should be given effect to, no matter that it may prejudice third parties, such as the holders of ship mortgages. Personally, I don't quite think that this is the correct analysis, and we should draw a distinction between the choice that the parties make in relation to the underlying contract and what law should apply to it. And it's perfectly all right for the parties to select US law to govern their bunker supply contract, even though none of them has a connection to the United States. But that should be kept a separate question from the issue of whether or not a maritime lien arises. And I think what the US courts currently fail to do is conduct a separate choice of law analysis for that question. And had they done that, they would have found that in the majority of transactions and the majority of ship arrests occurring in the United States, there is very little connect the issue of whether a maritime lien exists to the United States. So it cannot be governed by US law. I think.
So you're saying, just so I understand your point is that parties can incorporate US law, and that's different to, well, when it comes to the question of whether a statutory lien is created or not, your point, if I understand it right, is that there should be some connection with the US jurisdiction for that statutory lien to be arising. Otherwise, what's effectively happening is that you are, through choice of law, creating a contractual lien, albeit through, incorporating a statutory provision. So and I think there's something to that, isn't there? If you have a contract that has a connection with a jurisdiction, and that jurisdiction allows for the creation of a statutory lien, and there's some jurisdictional connection with that place, then you can see how it makes sense to allow the statutory lien to override other interests and what have you. But it's almost like a loophole to say, well, through contract and through incorporation, we're going to just, choice of law, choose the US and then get the statutory lien. You're almost, and you can imagine you could find any jurisdiction out there. The US is a big one and has a lot of interest in maritime, but you could go to some, far-flung jurisdiction that has some curious statutory lien law and incorporate the laws of, whatever country and they get some regime into the contract.
It's hard to say that it's difficult to say that statutory regime or that legislative regime that regime, which is unique to that jurisdiction, should have something more than contractual force.
Yes.
When the only reason for it being in the contract is contractual agreed.
Exactly. And have I understood your point?
Yeah. I think that's quite right. And I think that the US courts, like, for example, the court in the bulk Juliana case in the Fifth Circuit, is engaging in a bit of a hypocrisy when they say that, well, the parties are free to choose the law which applies to their contract, and therefore their choice of US law as creating the maritime lien is valid. I think they're blending two separate inquiries here, whether the parties have the right to choose the law applicable to their contract and whether the parties have the right to basically create a new lien which would not have existed but for their contract. I think, after all, it's a bit of a political decision here, or a public policy decision, because on the one hand, you've got countries like England or Singapore, which have decisions like the Halcyon Isle to protect the ship owners, to protect the third parties which might be prejudiced by the maritime lien. And on the other hand, you've got the United States, which used to be, and perhaps still is in many respects, a pro-supplier jurisdiction, which favors those who provide services or fuel, for that matter, to the vessel. So, in some sense, it may be US courts saying, well, we don't really care that Singaporean law would not allow lien to arise in these circumstances. We think that US law should apply because we care about fuel suppliers or providers of necessaries. And, whether that approach is sound as a matter of public policy is one question, but I just don't think that the legal analysis that the US courts engage in is entirely correct. I think they're missing that distinction between the underlying contract or the underlying claim and whether maritime lien exists to secure it. So, to my mind, the more correct position would be to analyze those questions separately and to see whether the maritime lien issue has any connections to the United States. And in most cases that reach US courts now.
It's a very, very interesting point, Philip. And I'm glad I asked whether you had any final thoughts, because I think we've doubled the podcast length, but I think you all agree that there's some really tricky issues in all of this, where different jurisdictions approach this question differently. And as you say, there's perhaps public policy grounds that go into that. Thank you everyone for listening in. Back in the saddle for our second series. It's been a real pleasure to have you on joining us, Philip. Thank you.
Thank you very much for having me.
Yeah, not at all. It's been a good one. Calum, it's good to be back.
Good to be back. And I would just reiterate what you said at the start of the podcast, which is that we are recording this from our firm retreat. So if there's any background noise, we're not on our usual sound paneled walls.
Yeah, exactly. We'll see how it sounds. Thank you, everyone. Please do follow us. Click to that subscribe button. We'll be getting back into our regular flow of weekly podcasts on case by case. So thanks again. Until next week, take care.
Cheers, everybody.